Hey everybody, it's Mike Kennedy, back in my garage for part 2 of the instant analysis of the PR Madness bracket. In part 1, if you haven't watched it, you should, because I explain what this is, what I'm doing, why there's a car right here, why there's beer cans up there. Basically, on Sunday, as a diversion to myself that I hope to use as a learning tool for everybody, and also maybe a diversion too, I created the PR Madness bracket. It's a bracket full of terms from professional responsibility and legal ethics, terms, concepts, rules, issues that come up in the inquiries I receive, the complaints I screen, the questions I get at CLEs. And I put them into a bracket that looks just like the NCAA tournament bracket, a tournament that's not happening this year because of the coronavirus public health crisis. Related to that, I hope everybody's okay, being safe, being healthy, being good to others, kind, supportive, good to yourselves. Anyway, in real life, they go through the bracket after it's released, quadrant by quadrant, tell you who's stronger than it might appear, who's weaker than it appears, who they think is going to advance. That's what I've done. In my first video, I went through the quadrant on the upper left. You should go here right now, find that PR Madness bracket tab at the top. Click on it. When you get inside, click on full bracket. We're going through the lower left quadrant in this video, the quadrant that includes the terms and phrases related to conflicts of interest and client confidences. One thing I did not explain in the first video, my Vermont gear, my vest, my hat, the shirt over here. Because this relates to basketball, because I'm a huge fan of the UVM men's basketball team, Coach Becker and Coach Saplicki, all the guys, feel horrible for them, for what happened. Didn't get to play in the conference championship game where all the fans would have been wearing this shirt right here. Not everybody in that shirt. Everybody would have had one just like it. And the fact that they didn't get a chance to then advance to the tournament, and even if they had, the tournament obviously canceled. Thank you guys for all that you do for this community. You've handled all this so well and with such grace. Really proud of y'all. Anyway, in this bracket, the top seed. Do I have to withdraw, Mike? Can I withdraw, Mike? Does the other side have to withdraw, Mike? So many questions I get on when can a lawyer withdraw, when must a lawyer withdraw. The rule is pretty clear, although it can be tricky to apply. Don't want to go too much further because it could get so far astray. Just get a lot of calls about this. I will make one thing clear. I will never tell you, yes, your adversary must withdraw. I will tell you what things you should be thinking about if you're considering filing a motion to disqualify. I will never say, yes, they must withdraw, or yes, they should withdraw, or yes, they have a conflict that disqualifies them, because I simply don't know without talking to them. That goes up against the 16 seed, non-lawyer ownership. That's 2 separate words. You can see it on the screen on the blog if you're there. Right now, lawyers are prohibited from practicing in any form of a for-profit law practice in which non-lawyers have an ownership interest. The PRB on Friday, this coming Friday, was scheduled to start considering whether we should relax that prohibition to encourage non-lawyer ownership, which perhaps might bring in not only investment, but expertise in how to run a business, how to deliver a product, that product being legal services. Right now, not allowed, Rule 5.4. The 8th seed in this bracket on conflicts of interest and confidences, joint representation of multiple clients. A lot of times I get calls from people who are representing multiple clients where up front, say after the car accident, the passenger, the driver, the person in the back seat, they're all on the same page and they want to save money, so they're going to hire you to do it all. Later on, when it comes to divvying up the pie, they're not so happy. I've seen the same thing very often when it comes to multiple heirs to, say, the same estate. They love having the same lawyer up front, saving money, but wait a minute. My brother's getting a lot more than he deserves. He never even helped out. Be careful in those situations. Number 9 here, someone other than the client is paying you to represent the client. Remember, the confidence go to the client or owed to the client, not to the person who's paying you. Just because mom is paying you to represent son in a DUI doesn't mean you can disclose to mom all of the confidential information that son conveys to you when you're speaking with son. Winners there. Whoever gets the most votes, they'll move on. Right here, number 5 in this bracket, screening and imputation. Can we screen off the lawyer who has a conflict, Mike? Vermont's rules are pretty strict when it comes to screening. Remember, we impute, the next phrase, almost every conflict from one lawyer in a firm to another lawyer in the firm. Exceptions, personal interest conflicts. What are those? For example, the firm's going to represent a client who's suing my kid's swimming coach. That would make me a little uncomfortable, but it doesn't pose any problems for anybody else in the firm, so they can take it. My personal conflict is not imputed to them. We also do not impute conflicts that arise when someone has a former client from government practice and now they're in private practice that would otherwise knock out that lawyer who used to be in government practice, but it's not going to knock out the rest of the new lawyer's firm. Same for lawyers moving the other way. The 12 seed here, CC and BCC on email, confidences. When you CC a client on an email that you send to opposing counsel, I think you put your client at risk of replying all by mistake and sending to opposing counsel information that your client meant only for you. Remember, the cure is not to BCC your client on the email you send to opposing counsel. A lot of people don't believe me on this, so at seminars, we test it and I prove it. The blind copied recipient on many email clients can reply to all. Related to this topic, do you have a duty to disable autocomplete? How many of you have started typing an email, not paid attention to the autocomplete? It went to somebody else than who you intended to send it to. What if that was confidential client information that you improperly disclosed? The number 4 seed in this bracket, related to withdrawal, noisy withdrawal. How much can you disclose in a motion to withdraw? I think the best answer is to cite the particular provision that either permits you or requires you to withdraw in Rule 1.16, and that's it. When the judge orders you to provide more, provide a little bit more, but just enough to get your point across. And finally, in this section of the quadrant, the conflicts that result from between changing jobs, we call them lateral transfers. The lawyer who moves from one firm to another firm, if that lawyer participated personally and substantially in a matter at this firm, moves to this firm who represents the other side, the firm's knocked out under Vermont's rule. I think we need to look at relaxing that rule. Okay, so that's the top half of this bracket. Really strong bracket, I think. Based on the calls I get, I'm going to say that, I'm under pressure here. I think whoever wins this matchup is a threat to advance throughout. Okay, moving on. The bottom half of this bracket on conflicts of interest and client confidences. Keeping this intentionally low tech, which I'm assuming is nothing confidential. It's pretty obvious. Anyway, the 6C down here, duties to prospective client, the client who meets with you but doesn't hire you. You must continue to maintain that prospective client's confidences as if the person had hired you. There are situations, though, where you can appear adverse to them, even on the matter they discussed with you. The rule says that's when you did not receive anything that could be significantly harmful if used against them. That faces off against the conflicts that arise when a lawyer is a witness. It's Rule 3.7. A tip there, it applies at trial. I think there's an argument that it only applies at jury trials, not at bench trials, although we've not had to litigate that here in Vermont. Number 3, tons of calls on this. Rule 1.9a, the former client conflict rule. You cannot represent somebody new whose interests are materially adverse to those of a former client in the same or a substantially related matter. Get lots of calls. Mike, is this substantially related? Really a fact-specific inquiry that there's no real standard. It's going to depend on the, again, fact-specific of each case. Just remember, if two matters are substantially related to each other, it doesn't matter, no pun intended, that you don't remember anything about the previous case. I get that all the time. Mike, yeah, they're substantially related, but I don't even remember the guy. Doesn't matter. We've said that clients are not going to have to disclose the confidences you are presumed to have received the first time in the form of representation in order to protect them or disqualify you in the next case. Number 14, sex with a client. That rule passed 2 years ago. Thank goodness. It took me forever to get it passed. I can't believe it took that long to get it on the books here in Vermont. That is a conflict of interest. We used to be in a situation where the comment to Rule 1.7, the rule on conflicts, said, well, sex with client, we're not going to affirmatively prohibit it. Might be okay, it might not be okay. We finally got the rule passed after some unfortunate experiences with lawyers who were essentially, and these are reported cases, having sex with clients who could not pay their bills, who were vulnerable clients. Not a good thing. I'm glad we got that rule passed. Only exception under the rule, the sexual romantic relationship predates the attorney-client relationship. But even then, remember, there might be times when you're having talks, they're not privileged, so be careful. The 7-10 matchup, just mandatory disclosure of client confidences. My client is going to tonight's basketball game with a bomb, is going to set it off in the gymnasium. He asked me for advice on how to get away from the police afterwards. Probably a mandatory disclosure. Permissive disclosure comes up way more often. What can you say but aren't required to say? The sad one in Vermont. You reasonably believe a client's going to take the client's own life tonight. You're permitted to disclose. You're not required to disclose. You're permitted to disclose. Unfortunately, I've had to respond to that question 7 or 8 times over the last couple of years. Also permitted to disclose in response to an ethics complaint, a malpractice suit, a petition for post-conviction relief. Remember, negative online reviews do not fall under the exception that applies to those claims and controversies between you and the client that I just mentioned, the ethics complaint, the malpractice suit, or the PCR. Moving on, the issues related to client confidences that come with electronically stored information. You have a duty to take reasonable precautions to prevent electronically stored information, both in transmission and at rest, from being inadvertently disclosed or from someone gaining unauthorized access to it. Can you store in the cloud? Depends. Is it a reputable company? Do you know if they just let anybody log in and see the information? Will they let you know if somebody hacks into them? Same questions you'd ask the person who owns the Storall facility out on the Old County Road. And number 15, generally known versus public record. Rule 1.9c, can't use or disclose any information relating to a former client unless it's generally known. A lot of people think, well, it's public record, I can talk about it. No, that's not what the rule says. Many courts around the country who have addressed it said just because something is public record does not mean it's generally known. The example I've used is, let's say 20 years ago I went through a divorce. I didn't, because I never got married. Sorry, Mom. But let's say I did, and a lot of dirty laundry came out in court, and tomorrow I'm applying for some job that's rather public, and my lawyer has had a falling out with me and doesn't want me to get the job, so wants to talk about all the things that came out in court, public record. So blabs them all. No, nobody even knew I got divorced. Nobody even knew I was married. So it's not generally known. Just because somebody can go look it up doesn't make it generally known. Another tough quadrant. So I would say out of this section of this quadrant, I think same or substantially related is a strong, whatever we're calling it in this bracket. And so is the winner of this one. Get a lot of calls. I don't know how I underseeded this way down here at 15. Probably because the answer is just because it's public record doesn't mean it's generally known. So there you have it. I'm going to end now. Then I'll come back and move over to the upper right quadrant of the bracket. Thanks all for listening. Bye.